Hi everybody and welcome to my YouTube channel. This is Hirshita Raji and today we are going to solve 2023 AIB question paper. So let's begin this video. So I'll make this video in parts so that you can comfortably watch all the solved questions. So let's start. The first question is the concept of freedom of trade and commerce mentioned in the Indian Constitution is motivated from the experience of which country? So the correct answer to this is Australia. In Article 301, you can find this related content in Article 301 of the Indian Constitution. So the next one is question number 2. Which of the following writ is issued to enforce the performance of public duties by the authorities? So the answer is direct and it is mandamus. So the meaning of the word mandamus is we command. We command. Okay, so this is the correct answer. A is the correct answer. Similarly, question number 3. Which of the following constitutional amendment act had made the provision for publishing Hindi translation of the constitution? So the correct answer for this is the 58th amendment. So this was made in the year 1987. So this made provision for an authoritative text of the constitution in Hindi language. So the next question is question number 4. Which of the following is a landmark judgment on the colorable legislation? So we should first understand what is colorable legislation. Colorable legislation is something that if you cannot do, or if you are not permitted to do something directly, you are also not allowed it to do indirectly. So that is what it means by colorable legislature. So the answer to this question is that option number A, State of Bihar versus Kameshwar Singh. So the doctrine, this doctrine, okay, it refers to the legislation that appears legitimate, but in actuality, it is outside the authority of the legislation. So that is what it means. So the next question is question number 5. So which of the following constitutional amendment was passed in the light of advisory opinion received in Berubari case? So we know that the landmark Berubari case. So this actually is the correct answer to this question is the Constitutional 9th Amendment Act, which is option number C. So this case was something which was passed in the year 1960. This constitutional amendment was passed in the year 1960 and it was an agreement with respect to the exchange of enclaves with Pakistan, and in response to the Supreme Court's advice in this Berubari case, this was done. So we can also understand the Nehru-Noon agreement. So that is also with respect to the same constitutional amendment. So the next question is question number 6. So which of the following provisions of the Constitution of India is relevant for solving the question of repugnancy between the center and the state law? So this is the direct question. So you can check each and every article in this, and the right answer is answer number C. So in case of any conflicts between center and the states, so this article tells that the state laws will be prevailing over the center law will be prevailing over the state laws. State is greater than center with respect to the laws. So the next question is question number 7. So the transition period was provided in Constitution of India for changing official language of Union from English to Hindi. What was the time period? So the correct answer is C, 15 years. So this was allowed for the smooth transition from English to Hindi. So the next question is, in which of the following case it was held that there could be no reservation on a single post in the cadre? So the direct answer to this question is answer number A. So Chakradhar Paswan versus State of Bihar. This is the answer to this question. In this, the Supreme Court held that the reservations cannot be applicable to a single post within a cadre, and because it will be violating the principle of equality. So moving to the next question, question number 9. Sexual harassment of working women at her place of work may also be considered as violation of which of the following provisions in the Constitution of India? So if we look into all the articles, it is Article 19. In this, if we look into detail, it is Article 19 of 1 of G. So in this, the Constitution tells that to have right to work in a safe environment. So right to work. So this is the appropriate answer to this question. So question number 10. Which of the following doctrine has been applied to resolve the conflict between Article 25 of 2 of B and 26 of B of the Constitution? The answer to this is the doctrine of harmonious construction. So the thing is that harmonious construction means that without any conflict, there should be no conflict. Without that, we have to interpret the constitutional provisions by ensuring cohesive application. That is what this harmonious construction means. So this is the appropriate one. So question number 11. Which of the following in which of the following situation IPC 1860 may not be applicable? So that is the question. So let's read into the options. An offense committed by Indians outside India, an offense committed by a person in any ship registered in India, and any person committing offense targeting computer resources located in any country. So the correct answer is C, option C. So the IPC 1860, it has extraterritorial applications in certain cases of crime by Indian citizens outside the India. This can be seen in section number 3, and the second option, that particular provision is in section number 4. So however, if any offense that is digital, like targeting computer resource, it will be not falling under this IPC. So it will be in the IT Act, something like that, IT Act. So next question is question number 12. How many types of punishments are currently existing in India under Indian Penal Code 1860? So this is very direct answer. The correct answer to this is 5. You can find this in the initial sections of the IPC itself. So this is the answer. Next one is question number 13. A and Z agrees to fence each other for amusement. In the course of such fencing, while playing fairly, A hurt Z severely. Which of the following offense is committed by A? So this first thing that we have to see is that A and Z agrees. Okay, so there is consent here. There is mutual consent, and by consent we mean that we know what is the positive as well as the negatives of the consequences. So here there is no offense committed by A. So this is the thing. Next question is question number 14. In which of the following situations right to private defense cannot extend to causing death? So in case when an assault is causing apprehension of murder, this is wrong. In case where assault is reflecting intention of committing rape, this is wrong. In case when assault is reflecting intention of causing simple hurt, so this is the correct answer. In case when assault is reflecting intention of gratifying unnatural lust, so this is the wrong answer. So in the right to private defense extends to causing death only in case where there is a reasonable apprehension of death or grievous hurt, rape, unnatural lust, kidnapping and wrongful containment. So an intention to cause simple hurt does not cause into this private defense. So you should read the question, it is not. So this is the thing. So simply if you want to understand that in case of any serious harm only then this right to privacy defense to cause death will be applied. Next question is question number 15. Which of the following sections of the IPC 1860 the word benefit does not include pecuniary benefits? So the answer to this question is section number 89. So if you look into each sections, you will be able to understand that benefit here. So benefit in the section 89, it implies to well-being and not the money. So pecuniary benefit is money related benefit. So this is not there in section number 89. The next question is question number 16. X intentionally pulls up a woman's veil without her consent, intending to annoy her. As per IPC 1860, which of the following offense has been committed? So this is a direct answer. B, it is criminal force, because intentional use of force comes under criminal thing. So even if there is no physical harm, there is still it is called criminal force. So next question is question number 17. What punishment is prescribed under the IPC 1860 for a person who maims any minor in order to such minor may be used for the purpose of begging? So this is like trafficking, so that related. So the direct answer to this question is imprisonment for life and fine, which is option number D. So this you can find in section number 363A of the IPC. So it is a serious crime under the IPC, and it is warranting to the highest level of punishment. So the highest level of punishment is imprisonment for life and fine. So the next question is question number 18. X threatened to publish a defamatory libel concerning Y unless Y gives him money. What is the following punishment? Maybe which of the following punishment may be given to X for the commitment of this kind of crime? So this is the question. So the direct answer is B, imprisonment up to 3 years with fine or with both. So this is the answer. So we can see under section number 503 and 506 of the IPC. So threatening somebody for money or something like that would and also like gaining through defamation, so this is considered as a criminal intimidation under IPC. So this is the answer. So the next question is question number 19. Which of the following sentence is an assistant session judge authorized to pass as per the Code of Criminal Procedure 1973? So this is so let's look into the options. Sentence of death, no, because additional session judge it is there. So sentence of death, no. Sentence of imprisonment for life, no. Sentence of imprisonment for a term not exceeding 10 years, yes, this may be correct. This is the correct answer. Sentence of imprisonment for a term exceeding 10 years, no, this is not the correct answer. So the other three options here are given to the higher judiciary, like High Court, Supreme Court, so they can do that. So the next question is question number 20. A person arrested by a private person for committing a non-bailable and cognizable offence shall be re-arrested by a police officer if such person comes under which of the following provisions of CRPC? So the direct answer to this question is section number 41. So in this section, the police officer is empowered to arrest a person without a warrant, like in cases involving like cognizable and non-bailable offences. So this is the answer. Next is question number 21. Under which of the following situation wife is not entitled for maintenance under section 125 of the CRPC? So we have to open the 125th section of the CRPC. So in that the correct answer is voluntarily wife refuses to live with the husband. So under this section 125, of the CRPC, a wife is not entitled to any maintenance if she voluntarily refuses to live with her husband without sufficient reason. So however, if she is forced to live separately or if the husband's conduct is unreasonable, then she is entitled for the maintenance. Next, question number 22. Which of the following procedure is dealt under section 164A of the CRPC? So open the section 164 and then you will find the answer. So the first one, medical examination of the victim of the rape. This is the thing which is provided under this. So it actually mandates a medical examination for victim of sexual assault, and it aids in collecting evidences and providing care. So this is the answer. Next question is question number 25. Which of the following is incorrect with respect to diary of proceedings in investigation as per the CRPC? So the answer to this question is C. The diary may be used as an evidence. So why exactly this option? Because investigation diaries are not admissible as evidence. They serve as the record. They act as a record to support the investigation. So we have to look into the questions properly. They have told incorrect. So the diary may be used as evidence. That is the incorrect option. Next, question number 25. Which of the following cases manners of committing offence is not required? In which of the following cases manner of committing offence is not required to be mentioned in the charge as per the CRPC? So if we look into the options, first option, A is accused of theft of certain article at a certain time and place. So this is actually the correct answer, because details of the offences manner are not always required. So theft of a certain article at a certain time and place, you will not know sometimes. So this is the correct answer. A is the correct answer. Next question is question number 25. Which of the following offence may be tried summarily as per the CRPC 1973? So the answer is, let's look into the question options. So option A, offence under section 454 of IPC. We should check into what is 454 of IPC. No, this is not the answer. 504, no. Offence punishable with imprisonment for a term not exceeding 2 years. So this is the answer actually. So summary trials are suitable for minor offences. Minor offences only with lighter punishment. So this is the thing. So that's it for this video. I'll make another video so that we will be able to complete all the questions of this 2023 AIBE question paper. Thank you so much for watching. Make sure you subscribe so that as soon as I post a video, you will get the notification. Thank you so much.